attorneys, state's ready?
Yes, Your Honor.
Defense is ready?
Yes, sir.
Bring them out. Please be seated. I'll ask our jurors again, have you followed my instructions, not talked about the case among yourselves or with anybody else or looked up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. Next witness, defense.
Judge, at this time the defense would rest.
Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. State.
Please, court.
Yes, sir.
Counsel.
Ladies and gentlemen, good afternoon. Okay, so now we've reached the end of this journey. And in a little while, you're going to have to go back there and make the most difficult decision you've probably ever had to make. We have to stand here and ask you to make that decision. I know that I can hear the sniffling. I know that some of us are sick, caught a head cold. Some of us are coughing, want to go home, go to bed. But we've all got this job to do. We all have to follow the law. During my first closing statement, I talked to you about the covenant of marriage. Remember that? And how Mr. Sievers breached it, how he broke that covenant. There was also a covenant of fatherhood. We heard that during the mitigation stage. He breached that. The issue here is not whether or not Mr. Sievers is guilty. You've already made that decision. The issue now is the more difficult decision about which penalty to recommend as a jury. You get to use your common sense in reviewing the facts of the case. And again, you didn't hear any other than victim impact, and victim impact is not to be used as aggravation. It is a right that the victim has to make that impact statement. But the evidence of aggravation you heard during the guilt phase. And if you can recall it several times during jury selection and even during my first argument, I begged you not to make a decision on the penalty phase without having penalty phase law. And this is why. You need to have the penalty phase law to make that decision on the penalty. You get to use your common sense in doing that review. And you're going to do the same review that you did during the guilt phase. You're going to apply the law that you're going to receive from the court to the facts that you heard during the trial and during the penalty phase. And after you apply the law to the facts without passion, without prejudice, using common sense, make a decision. We're going to ask you to do, on the one hand, it seems like a simple act of checking boxes on the penalty phase verdict form, but it's not a simple act because of the possible ramifications of checking a box or not checking a box. Okay, that decision is not only important to Mr. Sievers, but it's also important to the people of the state of Florida. So the purpose of this proceeding is to review the required aggravating circumstances along with any mitigating circumstances. Those aggravating factors have to be proven to you beyond a reasonable doubt. And the evidence that you heard of the aggravating factors was that the first-degree murder, or the allegation that the state has made, much like an indictment, we had to prove the allegations in the indictment beyond a reasonable doubt. We had to prove that to you. Well, we also had to plead the aggravating factors, and we have to prove those aggravating factors beyond a reasonable doubt. And the state submits to you that we've done that. The second aggravating factor is that the murder was committed in a cold, calculated, or premeditated manner. Attorneys often refer to that as the CCP aggravator, cold, calculated, premeditated. So, what was the evidence of cold, calculated, and premeditated? We're going to talk about that. But one of the instructions that you've already heard, and you'll get to hear, is that you are instructed, along with the evidence that you heard during the guilt phase of this trial, so you get to use the guilt phase evidence that you heard along with any evidence that you heard during the penalty phase in making the determination. You have 5 factors. Whether each aggravating factor is proven beyond a reasonable doubt, okay? Whether the aggravating factors are found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. Whether mitigating circumstances are proven beyond a greater weight of the evidence. Okay, and that's a burden of proof that the defense has in the penalty phase. Whether the aggravating factors outweigh any mitigating circumstances, and whether the defendant should be sentenced to life imprisonment without the possibility of parole, or whether the jury should recommend a sentence of death. So the aggravating factor of pecuniary gain, pecuniary is another word for financial, whether or not there's evidence that the defendant committed this crime for financial gain. Well, you heard that evidence. There was no need to repeat it during the penalty phase. In fact, that financial gain was a central part of the conspiracy to commit murder of which Mr. Sievers has been convicted. He told Mr. Wright that his plan was to obtain the insurance for Dr. Sievers, the life insurance, and use that to pay for the hit. So the insurance money is a fundamental part of this conspiracy. Without the insurance money, without the promise to pay from the insurance money, there is no conspiracy. There wasn't any premeditated murder without that promise. This was a set of circumstances that was put in place by Mark Sievers. But for Mark Sievers' involvement, Dr. Sievers would be alive. This would not have happened without him. And we're going to talk a little bit about that later on when we get to the mitigating circumstances. So the insurance in Exhibits 61, 62, 63, and 64, you can write those down on your notepads if you want. I'm trying to lay a road mark of some of the exhibits that you've seen. You can see them again. You can see all of the exhibits again if you want. You can see any exhibit that you want. It was to be used for payment, and you heard from both Mr. Wright and Miss Baradelli, who are not friends. The girls will be well taken care of. They both said the same thing. You know that the defendant knew the value of the life insurance policies because he hired a lawyer, a board-certified estates and trust lawyer, to counsel him. You got to see her testify. And even though she wouldn't answer counsel's, she wasn't too good at answering Ms. Ross's questions, she did establish that she had provided advice and counsel to Mr. and Dr. Sievers on the life insurance policies. He knew their value. Ms. Ross reminded you during her opening statement that Mr. Sievers was the trustee. He would have had control over the insurance policies. It was his money. cold, calculated, and premeditated manner. You're going to hear instructions that cold means the murder was the product of calm and cool reflection. And this is more than just the premeditation that was required for first-degree murder. This is more than that. Okay? Calculated means that there was a careful plan or prearranged design for the murder. Okay? The killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the time of the mind of the killing, and there's no exact time that must pass between the formation of the premeditated intent and the killing. It must be long enough to allow reflection by the defendant. The premeditated intent must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. Substantial. Did you see evidence of that during the trial? Of a substantial period of reflection? There is no pretense of moral or legal justification, and that is any claim of justification or excuse that, though is insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. There's been absolutely no evidence of any pretense of moral justification. What moral justification could there have been for Mr. Sievers to hire someone to kill his wife and mother of his two daughters? There is none. There's no evidence of any. So the plan starts when we talk about the heightened period, the heightened level of premeditation. You heard from the neighbor who says, Ms. Torres, the recon mission. Remember that? Recon mission to her house. She finds Mr. Sievers out on her lanai, right here. The back door where he had told Mr. Rogers or Mr. Wright to break into the house and make it look like a break-in was right here. Okay? That happened in January or February of 2015. And the state submits to you that every act, everything Mr. Sievers did to make this crime happen was part of that heightened period of premeditation. Okay? We saw this slide during the first opening, or during the first closing. Every phone call, and you can look at State's Exhibit 76 and 79, these are the burner phone calls between Mr. Wright and Mr. Sievers. Okay? Every clandestine, secret phone call here, and if you recall, some of these are duplicates because you're looking at calls sent and calls received, so they are duplicates. Every one of these, May 17th, multiple phone calls. May 21st, multiple phone calls. May 22nd, multiple phone calls. June 22nd, June 23rd, multiple phone calls. And then a phone call on June 25th, after Mr. Sievers destroys the hard drive and gets rid of the computer. Remember that? That's also part of the heightened level of premeditation required to find the existence of the aggravating factor of CCP. Again, the burner phone log and all of the phone calls between the two burner phones. Every phone call every secret phone call is part of the heightened level. State's Exhibit 25 and Defense Exhibit 2. We talked in the last trial about the secret communications, right? It starts out with, which is not on here. It starts out with it starts out with Mr. Sievers asking to speak with Mr. Wright at the wedding. Remember the trip that Mr. Sievers took to Missouri for Mr. Wright's wedding? The trip where he didn't visit his brother or his nieces and nephews? That trip? That's also part of the heightened premeditation. Okay? The request to speak to Mr. Wright. Since neither one of us are likely to carry both, I'm getting ahead of myself here. Let me look at my notes. Okay, so all right, here we go. The recon mission, the request to speak with Mr. Wright, the discussion in the bedroom with Mr. Wright that gets interrupted. You heard that from Mr. Wright, and you also heard that from Ms. Showmaker. Okay? That's part of the premeditation. Then there's a second discussion at the park. Remember you saw the picture of the two men changing. It's in evidence in the bathroom, and Mr. Wright told you there was another discussion that got interrupted as well. Then they took the ride to the store to pick up the tray of meat that Mr. Wright had left behind. That was the formal solicitation to commit murder. Heightened premeditation. Then the text messages. Secret communications. Since none of us are likely to carry both with us, whenever you want, just use the other one. Text me other, and then when I can, I will call. That's on May 7th. Every one of these acts is part of his cold, calculated, premeditated plan to kill Dr. Sievers. May 17th, check other. May 17th, hello brother from an other mother. We don't even have to talk about what all that means. We talked about it already. We know what it means. You know what it means. But that was an act and furtherance of this crime, an act of heightened premeditation. Okay, other, whenever you want now. Do you think we can talk tonight? Just need 3 minutes setting static IP T-home other than changing. Again, we don't need to discuss the meaning. We know what it means. We're here to discuss the significance of these chains of texts. The significance is that they are cold, calculated, and premeditated. June 24th, I will dispose of outdated computer tomorrow after erasing everything from its memory. So now we've gone from January or February to June. In May, Mr. Sievers purchases the burner phone. That's at Exhibit 67. In May, he develops the burner phone code other. In May, he makes requests to talk on the burner phones. In May and June, there are phone calls on the burner phones between Mr. Wright and Mr. Sievers. During those phone calls, Mr. Sievers provides Mr. Wright with information on where, when, and how this murder is supposed to happen. It can happen at the house, it can happen at the job. As Ms. Ross told you earlier, if it happens at the job, there can be no witnesses. Collateral damage. More evidence are the phone calls that don't happen. Again, we talked about these phone calls between their regular phones in June. We know that it happened. We know about the phone calls. We don't have to talk about whether or not they happened anymore. You can look at State's Exhibit 75, 80, and 118. We see all these phone calls, right? Then the phone calls stop. June 26th, the Sievers family leaves to go to New York. And then there's no phone calls on June 28th. We already know that that happened. We already know why it happened. But the reason it happened, it was part of that cold, calculated, premeditated plan to effect the death of Dr. Teresa Sievers. That's the reason. There's no need to call Mr. Rogers or Mr. Wright, because he's down in Florida killing Dr. Sievers pursuant to the plan. There's no need to call. There's nothing to discuss. There's no need to call on June 29th, the day Dr. Sievers is found murdered. We heard witness after witness who said Wayne Wright, Curtis Wright, and Mark Sievers were best friends, lifelong friends. We know that Mr. Sievers was told on June 29th that Dr. Sievers was dead. Well, he knew she was dead. There's no need to call his best friend. He knew it. That's what this means, the lack of phone calls. And then to get Scott Sievers to call and deliver the news on the 30th.
Objection to that is facts not evidence.
Overruled, the jury will rely on their own recollection of the evidence.
You heard the phone message on June 28th to Dr. Petrides. Again, you know that it happened. Why it happened. Why did he call Dr. Sievers on June 28th? To make sure that Dr. Petrides was home, that he was back in Lee County, because he was going to get called the next day, on the 29th, to go check on Dr. Sievers. Mr. Sievers can't bring his two daughters home with Dr. Sievers dead in the house. She has to get found before he gets home. That's the why. You heard about the discussion with Ms. Baradelli in the late night hours, early morning between June 30th and July 1st. The fake concern about the insurance policies, the policies that Mr. Sievers pretended not to know about. Again, we knew that to be false because we knew that he hired Ms. Lyons to counsel him on the life insurance policies. We knew that. The question is not whether or not it happened. We know that it happened. That's already been proven to you. Again, the question is why? Why did this happen? Why is he pretending not to know about the insurance policies to one of his wife's best friends? To one of his best friends? Why? The woman who was going to be the guardian of the Sievers daughters. That's how important Miss Baradelli was. The why. Part of the plan to cover up what he had done. The shredded disability policy. Remember, Ms. Lyons said that Dr. Sievers was uninsured, was underinsured. Why is the disability policy shredded? Why is the application for the policy shredded? It's an application. It's blank and it's shredded. Why? She wasn't going to need it. Again, evidence of the cold, calculated, premeditated nature of this crime. Mr. Wright says, you heard from not just Mr. Wright, but others that, he wasn't in the best financial situation. He wasn't going to be able to finance the trip to come down here to kill Dr. Sievers. And he wasn't going to get paid, as we know, until months after the killing when the insurance was paid. So Mr. Sievers sent him a $600 check. A check Mr. Wright told you he cashed, and he used that to help pay for the rent-a-car, pay for the gas, to buy food, snacks, clothes, and whatever else he and Mr. Rogers needed while they were down here. He said the plan was to make it look like a regular business check, which is why the check was drawn on the medical practice Bank of America account. That check put the amount of money owed to Mr. Wright for his services to the medical practice over the agreed upon amount of $100 a month. Why? The why, again, was to conceal the payment to Mr. Wright. That's why it was the medical practice account that was used. And we already know that Mr. Sievers went all the way to Missouri for a wedding. And even though he supposedly loves his brother's kids and spoils them, didn't take a 45-minute drive to go see them at all. The reason why is the purpose of the trip was the wedding and the solicitation of Mr. Wright to commit this murder. That's the why. Remember all the whys we asked during the guilt phase? This is where you get to answer those questions, where you get to answer the whys. In a while, you'll get a verdict form. And this is a much more involved verdict form than the guilt phase verdict form that you saw. In the guilt phase verdict, on the guilt phase verdict form, you had to choose guilty, lesser, or not guilty, right? Well, this is a lot more involved. One of the first questions you'll be asked is, do you unanimously find that the state established beyond a reasonable doubt the existence of capital murder, that the capital murder was committed for pecuniary gain? Do you believe that? Do you believe beyond reasonable doubt that this murder was committed for financial gain? All the evidence says that. If you believe that beyond a reasonable doubt, you have to check yes. Do you unanimously find that the state established beyond a reasonable doubt the existence that the capital felony was committed in a cold, calculated, and premeditated manner? Do you believe that beyond a reasonable doubt? Do you have any reasonable doubt? You have to apply your common sense. You have to make your decision without passion and without prejudice. If you believe beyond a reasonable doubt that this murder was cold, calculated, and premeditated, you have to check the box. If you answer yes, and this is where the verdict form in the penalty phase is a little bit more involved, if you've answered yes to at least one aggravating factor, then you proceed. You keep going. If you've answered no, there's no need to proceed. The sentence will be life. Okay? So if you answered no, if you don't believe the state has proven an aggravating factor beyond a reasonable doubt, you check no, and you stop. There's no need to go any further, okay? If you check yes, then you make a determination as to whether or not the aggravating factor is sufficient. In reviewing the aggravating factors, we unanimously find that the aggravating factors established beyond a reasonable doubt. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. If you believe that, you check yes. You check the box. Without passion, without prejudice. If you don't believe it, you check no. And if you check no, the sentence is life. If you check yes, you move on to Section C. This is the long form of the verdict form, Section C. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by greater weight of the evidence. Let's talk about the mitigating circumstances. Mark Sievers has no significant history of prior criminal activity. We agree with that. The defense has met its burden. We checked his criminal history. We agree. You don't have to use up time trying to figure out whether Mr. Sievers has a criminal history. He does not. Okay? That burden is met. However, his lack of criminal history doesn't outweigh the aggravating circumstances. It doesn't outweigh that this murder was committed for financial gain. It doesn't outweigh the cold and calculated and premeditated nature of this murder. The next one is Mark Sievers was an accomplice in the first-degree murder committed by another person, and his participation was relatively minor. So, yes, he was an accomplice. Yes, he was an accomplice. We agree to that part of the mitigator. But it also goes on to say, and his participation was relatively minor. Now, while Mark Sievers didn't lay a hand on Dr. Sievers and didn't strike the blows, any of the blows that resulted in her death, that was Jimmy Rogers and Curtis Wayne Wright. They wouldn't have been there but for Mark Sievers. Mr. Wright wouldn't have known that Dr. Sievers would be home. He would not have known that she would be home alone. He would not have had the alarm code to let himself into the house. He would not have known that the Sievers family would be out of town. He would not have known to explore doing the killing either at the home or at the business, as you heard. Mr. Sievers is not a minor participant in this crime. He is a catalyst. Mr. Sievers is when you strike a match, most folks don't use those anymore. He's the catalyst that starts the flame on the match. Without Mr. Sievers, this would not have happened. That mitigator has not been proven by greater weight of the evidence. And even if you do believe it has been proven, it does not outweigh the aggravating factors of financial gain and cold, calculated, and premeditated. The final mitigator, and this is what we call the catch-all. The existence of any other factors in Mark Sievers' character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. And we heard a lot about Mr. Sievers' childhood, his family, good people. We heard a lot about some of the values Bonnie Sievers instilled in him as a child, her religious beliefs. Those are all good reasons not to kill your wife. Those religious beliefs are a good reason not to kill anybody. But the question is whether or not they have met their burden by greater weight, and if you believe they have, whether or not it outweighs the aggravators, the cold, calculated, premeditated nature of the crime, as well as the pecuniary gain. They have not. They have not met the burden. No doubt, Mr. Sievers didn't have a persecuted childhood. A divorce is tough for any child, especially a 10-year-old. But he got to see and stay with both of his parents. Both of his parents stayed alive until one died of natural causes, of pancreatic cancer. There's nothing in those circumstances that's mitigating. Yes, he is a father. That by itself could be a reason to find that that mitigator has been proven. But the daughters and his custody of the daughters were also part of the motive for the crime, right? He told Mr. Wright that he believed his daughters would be in danger if there was a divorce from Dr. Sievers. So we submit to you that that has not been proven by greater weight of the evidence. And if it has, it doesn't outweigh any of the aggravation. So if one or more individual jurors find that one or more mitigating circumstances was established by greater weight of the evidence, check no. It was not. Then, if you do check no, the next question is, do you unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh any mitigating circumstances established? We submit to you that they do. They haven't established mitigating circumstances. The only one they've established is no significant prior criminal activity. We agree to that. If you answered yes to Section D, you go to Section E. And this is where you enter your verdict as to the penalty phase. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, and that the aggravating factor or factors are sufficient to warrant a sentence of death, and that the aggravating factors or factors outweigh the mitigating factors, we, the jury, unanimously find that Mr. Sievers should be sentenced to death. That's the important box. Use your common sense, use the law, use the facts, and make your decision without passion and without prejudice. Check the box. The state respectfully submits, ladies and gentlemen, as we send you, as you embark on this difficult journey that is the penalty phase, that death is the appropriate option in this case, based on this defendant, based on these facts, based on these aggravating factors, and based on these mitigating factors. We ask you to check the box. Thank you.